Well, good evening, everyone. I'm Dennis Stone, Director of the Center for Advocacy and Social Justice at the Jacksonville Urban League. And we're very pleased this evening to have several experts talk about the impact of the new bar exam and other things going on in law school accreditation and getting through law school and all that. And I'm particularly pleased. I'm going to let uh, Daniel Peter do the introductions. Daniel is one of our interns. Also with us is Saudia Barge, our coordinator of interns at the center. But I'm going to let Daniel do the introduction, but I did want to say that Scott DeVito, I worked with him as Dean of Florida Coastal for many years and wearing other hats as well. And just a wonderful person, and we're really pleased to have you with us tonight, Scott. And with that, I will turn it over to Daniel.
Hi, everyone. I'd like to welcome you all here today. I'm going to give some brief introductions for myself, and then for our speakers, and then we'll go into the topics, and then we'll do a short Q&A after, and then we'll wrap it up. So I'm a political science student at UNF. I do political science because I like studying about marginalized politics and its effects on marginalized communities in the United States, in Florida, and Jacksonville. And I find the major generally fun. After finishing up my degree here, I plan to do law school and work my way through that towards politics. I aspire towards a political career, and to kind of start that off, I wanted to intern with the Jacksonville Urban League and learn more about advocacy on the local level. JaxUL, for everyone that sees this and does not know, is a nonprofit special service and advocacy organization that takes a holistic approach to provide marginalized communities with tools they need to empower themselves toward a productive and more successful life. And today, for our tunnel, we're going to be talking about changes to the American Bar Association and to the bar exam. So our speaker, Scott DeVito, he will be talking about changes to the ABA. And then after that, we'll move over to Dean Lauren Knight, and she'll be talking about changes to the bar exam. So first, I'll introduce Dr. Scott DeVito, and then he can go into his presentation. So Dr. Scott DeVito is an associate professor of law at Quinnipiac University School of Law, where he teaches business organizations, commercial law, contracts, and evidence. He is passionate about helping students connect complex legal doctrines to real-world practice, blending analytical precision with a focus on professional identity and ethical judgment. Before joining Quinnipiac, Professor DeVito was a founding faculty member and a tenured professor at Jacksonville University College of Law, where he played a leading role in shaping the school's academic programs and assessment initiatives. He also previously served as Dean of Florida Coastal School of Law, guiding the institution through successful reaccreditation and implementing innovative strategies that improve bar passage rates and student outcomes. The scholarship explores the intersection of law, evidence, and artificial intelligence, as well as empirical studies on bias and fairness in legal education. Professor DeVito's career reflects a deep commitment to educational innovation and student success. He has received multiple grants for immersive learning and pedagogy. I don't know if I said that right. And is a frequent speaker at national conferences on bar passage, diversity, and inclusive teaching. Dr. DeVito, would you like to go into your presentation?
Thank you, Daniel, and thank you, Dennis, for those kind words. It was always a delight working with you as well. I've always considered you one of my mentors, and I appreciate the friendship. Let me share my presentation very quickly. Let's see if we can get it up there. There we go. All right. So I want to talk a little bit about recent changes in ABA policy and some issues relating to whether the American Bar Association should be the accreditor for law schools. So just to give everyone the background, the American Bar Association is the nationally recognized accreditor for U.S. law schools. Now, it's not the only accreditor. We have state accreditors as well, but principally it's the American Bar Association that accredits your law schools. That accreditation authority comes from recognition by the U.S. Department of Education. And graduates in all ABA accredited schools are able to sit for the bar exam in all U.S. jurisdictions. So if I graduate from Connecticut, I can take the bar from the University of Connecticut, Quinnipiac, Yale, any of those are ABA accredited. I can take the bar exam anywhere in the United States because I graduated from an ABA accredited institution. Something to recognize, though, regarding the ABA is that the ABA is, I believe it's every 5 years. I was actually talking to someone about this a week ago. Every 5 years, the American Bar Association is reviewed to see whether or not it's doing its job as an accreditor. And actually, it's going through that process right now. So the ABA is the accreditor, but as with any politically controlled system, there can be pressures put on the ABA. And since they're currently going through reaccreditation, you can imagine that some of these pressures in our modern environment are applying to them right now. So what does the ABA do? Well, to simplify it, the ABA puts out or promulgates a set of standards. They are rules about how we should run law schools. And if you run your law school in a way that's consistent with the standards, you can be ABA accredited. It will cover things like institutional structure and governance. So what role does the faculty have in governance is an example. It will talk about financial resources and stability. Is there enough money in the university and in the law school to provide a proper education for the students? It'll talk about faculty composition, their qualifications. There's some discussion of curriculum and degree requirements, student support, law libraries, learning outcomes, and then most importantly for many law schools will be bar exam outcomes and employment outcomes. So the American Bar Association requires ABA accredited law schools to hit certain numbers in terms of students who pass the bar exam, and then certain numbers in terms of employment that those students have. And this can put a lot of pressure, as you can imagine, on law schools, because if they're admitting students who are not capable of passing the bar exam, they're going to run the risk of losing their accreditation. So the ABA enforces its standards through a couple of different ways. The first is an initial accreditation. So a few years ago, Jacksonville University started its own law school, as you all know, and that required applying to the ABA for what's called provisional accreditation. And the Jacksonville University got that with flying colors, highly approved. Everybody was very happy about it. Once you get provisional accreditation, you're eventually going to move to full accreditation, and that requires a certain amount of time to pass, and you have to have a self-study and a site evaluation from the ABA to make sure you're meeting those standards. Once you're fully accredited, which most law schools are fully accredited, then you go under periodic review. Every year you have to submit some documents to the ABA reporting what you're doing. And they use those documents to flag anyone who might or might not be at risk of violating the standards. So for example, a simple standard to think about is bar passage rates. According to the American Bar Association, you need to have a 75% of your graduates who take the bar pass the bar exam within 2 years of graduation. So you have to report your bar examination results to the ABA. Let's imagine that it looks to them like you're not going to hit that 75% number. The ongoing monitoring might result in a visit from the ABA to find out what's going on, or a letter from the ABA requesting additional information. Those ongoing monitorings can result in further investigations and eventually enforcement actions. These are made publicly available, the information about them, although a lot of that information is kept private for FERPA and other reasons. And so the idea is that you have your initial accreditation, they're paying attention to you through these data, the data that you provide every year. And then every 10 years, there's a big, what's called site visit, where the ABA comes and they take a very close look at your law school to make sure you're doing all the things you're supposed to do under the standards. There's a lot of benefits to this. One is that your students have eligibility to sit anywhere in the United States. It also theoretically improves quality, although it may or may not, right? This is the problem with accreditation. If accreditor's not doing their job well, you may not get that quality that you'd like. You have professional credibility, right? Employers, judges, and others really like when you come out of these schools. It's sort of a credential. You came out of an ABA accredited school. As part and parcel of that, you usually can attribute or attract stronger credentialed students. And as a result, that usually results in stronger outcomes. We all understand if someone's really good at taking tests and they get into your law school, then they're going to be really good at taking the bar exam. And if they're not very good at taking tests, then they're not going to be very good at passing the bar exam. So credentials like the LSAT or their GPA really affect where you end up in law school. And as a result, ABA accredited law schools tend to have better credentialed students than schools that aren't ABA accredited. To get financial aid, you have to be accredited by a U.S. Department of Education accreditor. And so that enables, it's one of the ways in which schools can get financial aid, being ABA accredited. There's commitments to ethics and professional responsibility and transfer of credits and degrees and things of that nature as well. We have some changes recently that I think are relevant, which are to the diversity, equity, and inclusion accreditation standards. So prior to the new standard, and that's 303C, there were no explicit diversity related or equity, a better way to phrase that is equity related standards. The focus really was on skills and professionalism in a general concept, and diversity across schools was very, very variable. Some schools have a lot of diversity, some do not. Some have a lot of focus on equity and inclusion, some did not. And that was built into the way that they were run, as well as to the educational system. The new standard implemented requirements for training in diversity, equity, and inclusion. So, for example, you'd have to worry about training your students for professional competency, and part of that is understanding bias, racism, and what's called cross-cultural competency. And what they did is they implemented standards for this so that there's a uniform minimum standard. You have to do at least this much. And it's very limited. So it has to occur at least twice. So you usually do this professional competency, cross-cultural competency at orientation, and then there'll be a later experience. Usually that's connected with experiential learning. You have to demonstrate that you're actually doing this, and you have to build in this notion of professional identity so that people understand the connection between cultural competence and being a professional and a competent lawyer. Now, as you can imagine, in the current political environment, there's been some pushback, not merely from the political perspective, but also from people not wanting the ABA in some sense to tell them what they have to do. So you have academic freedom concerns. If I don't want to teach that material, why should I be forced to teach that material? So there's some people complaining that it really is mandating an ideology as opposed to education. There are First Amendments saying that this requires or compels speech, so people are concerned about this. We, of course, have, as we're all aware, political polarization. DEI in certain states is part of a much larger debate and a bigger problem. In fact, in places like Florida, if you are at a state-owned school, DEI is not something you can really talk about. And I actually have colleagues in certain public institutions. And Jack, just so you know, Jacksonville University is a private institution, so they continue to have a deep interest in diversity, equity, and inclusion. And that my experience has always been that all of the administrators, faculty, staff are very much in favor of that there. But if you're going to somewhere like Florida State, the University of Florida, and other schools that are owned by the state, then there really is a problem if you want to talk about these issues. There's a lot of pressure that if you try to talk about them, you might get in trouble. And I know people who have tried and run into some real roadblocks. So we've got a lot of pushback on this across the country. From my personal experience, one of the things that I find problematic with the standard is it's vague and unclear what it means. So you're not always sure if you're actually doing what you need to do in order to achieve what they want you to achieve. And that has resulted in variability in the way it's been implemented. Some schools have done very minimal implementation, saying, well, that meets the minimum standards, and others have done more. Um, the ABA's response is, hey, this is really about professional preparedness and not ideology. And actually makes a lot of sense in one level because as we recognize, our country is becoming more and more culturally diverse. And so having people with a better, or lawyers with a better understanding of that makes a lot of sense. But it's come across in our current political debate quite problematic. What about standardized tests for admission? So recently, the ABA has allowed law schools not to rely on the law school admissions test, which is what when I went to law school, you had to take it. You had to get a decent score on it to get into law school. And so it really limited folks to their ability to get into law school. What happens is they loosened that, so now you don't have to rely on the LSAT. You can take things like the GRE, and that's what this slide is talking about. You can take the graduate exam as opposed to the LSAT. And the idea of that was to broaden the applicant pool. And in theory, it would lower costs for people who are already taking the GRE. They take the GRE, they don't need to take the LSAT. It was thought that doing this would increase diversity in admission pathways. My experience is this has not been the case. People really still do rely upon the LSAT, even if they claim that they do not, because the LSAT is a clear, objective approach. So, it's the goal was good, but whether or not it's actually done what it really needs to do is a separate question. And at first, if you wanted to use the GRE as opposed to LSAT, you had to agree to do these validation studies and report back your results and things of that nature. Now, in 2021, they said you don't need it. You can admit students without either the LSAT or the GRE, as long as you use a valid and reliable admissions method. Standardized tests are not required. And it's not on these slides, but I think it's important to note. If you look at the history of standardized testing in law schools, it was the number one way in which diversity was destroyed in law schools. When it first came out, there were many, many schools. I mean, it's during a period of segregation. So students, you had white-only schools, and then you had other HBCUs, for example. And those HBCUs would train people to be lawyers. Once people started creating these sort of requirements for accreditation that really tightened up all those schools, for the most part, went away. And you have a 90% decrease in the number of students from communities of color applying to and being admitted to law school at the time when you start implementing things like the bar exam and these standardized tests for admission. I want to point out my experience with everyone who builds these things and everyone who's involved in it directly indicates that they are not doing it for such nefarious reasons. Their goals are different, but it does have the effect of pushing certain people out from marginalized communities from becoming lawyers. Now, there's also a real push currently from certain states to allow their schools, their law schools, to be accredited by someone other than the ABA. The Florida Supreme Court formed a working group to study its ABA accreditation requirement. Ohio is doing the similar thing. Texas, the state Supreme Court issued an order asking for public comment on whether to end a requirement that you graduate from ABA accredited schools. And Tennessee is similarly asking for public input on reforms. So the idea is that people are worried that the ABA is, I guess the best way to phrase it is, I would imagine the folks in these states are worried that the American Bar Association is attempting to control ideology and the learning process of law students in a way that these folks think isn't necessarily to the best benefit of lawyers in those states. So I suspect in the next few years, the ABA may lose a few states requiring them to be accredited. But remember, if I want to take a bar exam in Florida, and then I want to go to, or I want to go to law school in Florida, but then I want to practice law in Connecticut, Connecticut's going to require me to graduate from an ABA accredited school. So the real issue you're going to face is If you graduate from one of these non-ABA accredited schools, where else can you practice other than the state in which you took the bar, you went to law school? There are a number of states currently that have state accreditation for law schools. And in those states, if you pass the bar at one of those schools that is only state accredited, that's the only state you can practice in. And that's the end of my presentation. And I will pass it over to Dean Knight, if that is okay.
I'll give a short introduction for D Knight, and then we'll go over to you again. All right. So Professor Lauren Knight began her legal career practicing in Jacksonville, Florida. She has recently served as Chief Operating Officer for a law firm in Savannah, Georgia. As a law professor, she taught and tutored law students and undergraduate students in academic success, LSAT and bar preparation. I might need some of that later on, I'm not gonna lie. Criminal law, legal writing, professional responsibility, and remedies. Professor Knight's research centers on the student experience in law school and legal training. She previously taught at Mercer University School of Law, Savannah Law School, and South University. Professor Knight, I'll pass it over to you now.
Thank you so much. Okay, let me share my screen. Good? Okay, so what I want to start with today is just, what is the bar exam and why does it matter if you're a law student? So just to get into some real basics, if you graduate from law school in Florida, does that mean you can practice law as a licensed attorney in Florida? The answer is no. Okay. Okay, you have to take this thing called the bar exam. So what exactly is it? As Professor DeVito already alluded to, it's a licensing exam for prospective lawyers, and it's required to practice law in a specific U.S. state or territory. It's not currently required in every state, but for the most part, this is the current system that we're operating under. When can you take it? This is a common misconception that I have seen even among some of our most informed law students. They think you can take the bar exam whenever you can register for an LSAT, or no. The bar exam is offered twice a year, and this is not Florida specific. It is offered the last Tuesday and Wednesday in July and February. So again, kind of going off of Professor DeVito's points, but what happens if I take the bar exam in one state? Does that mean I'm a licensed attorney in all states? As of right now, no. Every state is going to have at least some state-specific requirements. But what about the current Florida bar? Currently, it's a 2-day test. Part 1 consists of 100 Florida-specific multiple choice questions and 3 Florida-specific essays. Part 2, day 2, will be 200 MBE, also known as the multi-state bar exam multiple choice questions. That brings us to what is NextGen. So that's the current state of the bar exam, but what is this concept of NextGen? Before I say what it is, I kind of want to talk about the why. So one of my favorite quotes is that in a perfect world, there would be no tests, and a test like the bar exam would probably be outlawed instead of required. So originally, most bar exams were conducted orally. The early written exams that eventually evolved were criticized as too basic because they failed to test and assess the necessary level of competence needed to practice law. So the NCBE, the National Conference of Bar Examiners, was founded in 1931. It's a nonprofit corporation that has been in the business of drafting the bar exams ever since. So the predecessor to NextGen received its fair share of criticism, and we had old concerns resurfacing. The exam did not adequately assess an examinee's ability to practice law. So beginning in 2021, after years of gathering research, the NCBE tried to get together and figure out how can we change this bar. So What is NextGen's goal? Right, the goal of the new bar exam is to place a greater emphasis on foundational lawyering skills such as legal research, negotiation, managing client relationships, while also testing examinees on foundational principles. Just to give you kind of an overview, you can see the different doctrinal areas that will still continue to be tested. BizWorks, civil procedure, con law, contracts, criminal law. But these concepts will now also be tested in addition to the foundational skills: issue spotting, analysis, investigation, legal research, legal writing, client counseling, negotiation and dispute resolution, and client relationship and management. So what is the new test going to look like? Well, long gone is the MBE, the MPT, the MEE. If you do not understand what all of those mean, it doesn't matter, because by 2028, they're gone. Here is what NextGen will look like. It will have standalone multiple choice questions. They will either be single select or multi-select, which means you could be asked to select more than one correct answer. It will also consist of integrated question sets. Finally, it will consist of performance tasks. Just to very briefly go into what each of these will look like. When it comes to the multiple choice questions, to date, what we have heard that approximately 40% of the exam will be devoted to the multiple choice questions. They will give you between 4 and 6 answer options and 1 or more correct answers. Again, these questions will test not just on the doctrinal areas, but they will also pull from foundational skills. The integrated question sets are very interesting. I do feel like this is one area where it's still really up in development, but for right now, we are understanding that they will make up just 1/4 of NextGen, and some questions will test on doctrinal law, while others will focus on drafting or editing a legal document and or on counseling or dispute resolution. Last but not least, we get the performance task. So the performance task at first is going to seem very overwhelming. It's going to pose a question or a series of questions about a single fictitious client matter. The examinee will have 2 kinds of material with which to work: a file and a library. The file is going to tell you what you need to do through a short memo. It will include things like interviews, depositions, or other documents. Some facts in the file will matter, some won't. Some may be unclear or even contradict each other, much like when you enter the practice of law. Your client will walk into your office, and what they tell you on Monday might be a very different story from what they tell you on Wednesday. So part of your job in the file is to sort through that information, notice what's missing, and figure out what other facts you'd need if the question asks for it. You will also get a library, which might include cases, statutes, or other legal rules. Not everything in the library will be useful. Your task is to pull out the rules that actually matter and use them to solve the problem. What is actually great about this task that seems overwhelming? This goes back to the big idea, right? When it comes especially to performance tasks, NextGen isn't testing whether you memorize the law. Everything you need is in the library when it comes to the law. You just have to read it, understand it, and apply it like a real lawyer would. A real lawyer does not get to sit down at their desk. They are not given a clear and concise fact pattern from a client and asked to pick the best answer, A through D, as to what the client should do. The performance tasks are asking you to actually put your shoes in a real lawyer's position and see what the best outcome would be. So going back to Florida, remember I told you the current exam, day 1 is the Florida specific portion, day 2 is the multi-state portion. Since Florida is going to adapt NextGen in 2028, are they still going to require a state specific portion of the bar exam after the adoption of NextGen? all signs point to yes. We do not have official confirmation, but every meeting I have been a part of with the Florida Board of Bar Examiners indicates that they very much still want to keep a Florida component. They do not know what it looks like. They are working on it. As soon as we know, we will let everyone know. But as of right now, all we know is that Florida still wants to maintain the Florida specific portion.
All right. Thank you, Professor Knight, for your wonderful presentation. Now we'll go into the Q&A, and I'll go back and forth between you two. So the first question is for Professor Knight. How are these changes to the bar exam that test practical skills, more practical application skills, a strategy to address broader challenges by those working in the legal field?
That's a great question. Yeah, as I mentioned, back in 2021 is when the NCBE started gathering their research, and they actually spent a lot of time surveying lawyers out in practice and asking them, what can we do to help? Like, what do you need from us so that when you hire a brand new graduate from law school, that them passing the bar means more to you? That it means that they're understanding what it means to actually practice law. And so, again, NextGen has not been launched yet, but one of the very big goals is let's start testing more on legal skills and not just relying so heavily on memorization.
All right, next question is for Professor DeVito. So do the plans to halt requirements for AB accreditation in certain states like Florida and Texas have anything to do with skepticism of these new DEI standards? Actually, I heard that those standards were kind of halted a bit by the ABA, but what do you know about the updates with that?
Yeah, so it's very clearly, I think there's actually two components to it. One is that law schools, a lot of law schools felt uncomfortable with the requirement. And as a result, there was pressure from the law schools themselves. But I think the larger issue is that we have a political system in which those issues are really at the forefront. So I really do think that primarily currently the ABA is pausing these rules in part because of this political pressure. And remember, I had mentioned that the ABA is up again for its ability to be an accreditor, so it's being reviewed for that. So you can imagine that as they're going through that process, there is political pressure being imposed upon them. And then when you look at each of the individual states that are thinking about moving away from the ABA accrediting their law schools, part of why they're doing that are these issues about diversity, equity, and inclusion requirements by the ABA. So absolutely, I believe that it is connected to the DEI standards.
All right. Dean Knight, another question for you. Do you think that the inclusion of performance tasks will significantly affect bar passage rates? Could this new format make the exam more accessible for students who struggled with the memorization heavy format of the old version of the exam, or will emphasizing practical skills actually make it more challenging overall? What do you think?
Okay, well, to take the first point, I believe that it is too early to accurately assess what it will do to bar passage rates. I mean, the exam has not even been launched at this point. As far as making it more accessible for students who sometimes struggle with heavy memorization, I do believe that's one of the goals, right? Once we see how this actually plays out, we can hope that that is one of the things that it is achieving. And then the third question, can you refresh my memory?
It was will emphasizing practical skills make it more challenging overall in comparison to other exams that kind of have that same format?
I love that question because I think even with the changes, unfortunately, the bad news is for all law students, the bar exam is challenging, will remain challenging. It's just now it's posing different challenges that are just more real world and practical based.
Moving back to Dr. DeVito. Let's see. Okay, so do you think that the LSAT has evolved to be more inclusive of marginalized communities? Will the removal of current LSAT and GRE requirements in certain colleges have major impacts on their average academic first year law school academic performances?
So I think that it's pretty clear that they've modified the LSAT in a way that's responding to certain marginalized communities. So for example, removal of the logic games in the LSAT occurred after settlement with the blind test takers who argued that the section required diagramming that disadvantaged visually impaired candidates. On the other hand, they have expanded accessibility and remote options. So in that sense, the LSAT has given greater access to people with disabilities. I think removing the requirement isn't going to actually affect most law schools because what they're thinking about isn't the entering credentials, but the exiting credentials. If they exit and their students don't pass the bar exam, then they're in trouble. So what that means is if they choose not to use the LSAT, they will use other markers of ability to pass the bar exam that will result in the same outcome. So I think that you're not going to see much change. But you might see around the margins. Certain schools that market to weaker credentialed students might admit more, but I think they're going to be very cautious because if they don't hit their bar pass numbers, they could lose their accreditation. So I think it's mainly no. I don't think it'll affect folks, but it will around the margins.
Professor Knight, so another question for you. Do you think that changes to the American Bar Association and the NextGen bar exam involve any coordinated efforts to increase professional preparedness?
Absolutely. Whether we like it or not, the bar exam is still a very big part of most jurisdictions and your ability to practice law. And so gearing the bar exam more towards focusing on lawyering skills, I think absolutely reflects coordinated efforts to increase professional preparedness.
All right. Okay. Dr. DeVito. So states like Florida and Texas are making proposals to end ABA accreditation requirements for law schools under their jurisdiction. What implications would this hold for students attending a law school in those states?
Sorry. It's the primary issue. Hold on. The primary issue is going to be whether or not they can move to another state. So if you take the bar exam, let's say Florida adopts its own bar standards and does not allow ABA accreditation. And so we have to distinguish two things here. So I'll use California as an example. California has state accredited law schools and it has ABA accredited law schools. If you want to be ABA accredited, you can. If you want to be state accredited, you can. So the question is going to be whether Florida and other states like Florida will not allow people to be ABA accredited. If it does allow them to remain ABA accredited, but makes it sort of voluntary, then for the vast majority of law schools in Florida, there'll be no effect. If it, on the other hand, certain schools decide to go with state accreditation as opposed to ABA accreditation, the big effect will be ability and portability of the law degree. Being able to graduate in Florida and then take the bar exam. So for example, many students in Florida go back to Texas, they go back to New York, they go to Georgia, other states like that. If they're not ABA accredited, they won't be able to take the bar exam in those states unless those other states change their accreditation rules. So that'll be the big effect if the states move in that direction. But it will depend on whether the state says no ABA at all or simply makes it optional. You can either be accredited by the state or you can be accredited by the state and the ABA. And if you can do both, you won't have any impact.
Dennis, it seems you have a question that you'd like to ask. You're muted.
Sorry. Of those, of the accredited law schools, since the standards for 75% in 2 years past the bar, has there been any, are there any of the schools that have run into problems as a result of that? You're on mute.
Oh, sorry. My understanding is that a minimum number of very few schools have run into problems. If I am correct, I believe that Cooley School of Law has run into some problems with it, but the vast majority of schools have not had a major impact. And the reason for that is that they've raised their entering credential requirements. Dean Knight, I'm not sure if you know of any other schools that have run into accreditation problems, but I do believe that Cooley School of Law has.
Off of the top of my head, I agree.
And this one is for Professor Knight, Dean Knight. When you talk about the issues other than multiple choice questions and all that, would that be what was previously known as the question answer, like blue book style questions? Is that what they're talking about for in this new NextGen, or is that still something that will be separate from the exam?
That's a great question. So actually, and this might not be quite to your point, the concept of NextGen is also that it will be completely computer-based.
I heard about that, yeah.
Yeah, so long gone are trying to teach the students what a Scantron is. You know, long gone are the blue books unless, you know, you have certain.
No, I get that. It's just, I'm trying to express, you know, you get a question, hypothetical, and you type in an answer. Is that still will be part of the exam?
That will be part of it. It certainly will be part during the performance task for the integrated question set. They're still working around that. We've seen examples where the integrated question sets are multiple choice based. We have seen where it's a combination of multiple choice, short answer. We've seen integrated question sets, which is actually just one question. And all it is just a very long essay answer.
Right. So it's still possible some states would have this NextGen exam, at least a portion of it, and then they would have their own questions, and it'd be on computer, but
I don't know. Yeah, I don't know.
Graded.
I don't know if we can go that far yet. The way that they currently have proposed NextGen is that it should be a 1.5-day long test, right? The current, UBE test is a 2-day,
right,
hours each day. But then we have states like Florida saying that they do want to maintain at least their own state-specific portion. So theoretically, if they adopt all of NextGen, that could be a 1.5 days of NextGen testing, and then it could leave open an afternoon session for Florida. Although it has still not been ruled out that Florida could potentially move to a 3-day exam. They don't want to do that, but they haven't made a decision about that yet. And so we're going to just be watching and seeing what every different jurisdiction does. For something that kind of interests me, Florida is very concerned with what Texas is going to do. So they're watching Texas very closely, which means I'm watching Texas very closely. Because whatever Texas does, I think might give us some guidance if they say something before we hear from Florida.
All right, and just one comment. Being away from all this since 2018, I feel great. Not to have to deal with this stuff and worry about getting students, either into school or, well, although I was saying earlier, my daughter just took the LSAT, but wow. And then I just looked in the Wayback Machine, and the DEI was all over the ABA front page, and now they still have a diversity center on their website, which I thought was kind of interesting. Now, one last comment, and that is, it is a marker for getting access to student loans, going through that process. And even if they theoretically, if they got out of that, their university, as long as it was accredited, could get it. But if you look at it in the reverse, the federal government has control over the whole process. They've always had it, but now there's a certain person that may fully utilize it. So anyway, thank you for your answers.
And Lauren, if I may, part of the problem as well is if I'm understanding correctly, is that we're still not entirely sure what the next gen is going to look like. They still keep putting out new and different information. Is that right?
That's correct. That's why one of the most interesting things to me is these integrated question sets. You put an S on the end of question sets. I assume you're going to give me a sample that has sets of questions, yet I have seen samples where it is one question and just one giant essay response required from the students or the examinees, excuse me. So it continues to change. One thing I'm very grateful for is that Florida is one of the jurisdictions holding off until 2028.
Mhm.
Because I want to see what this looks like in 2026 and then again in 2027. Because my own personal opinion, I think changes will be made.
Right.
So the first one that comes out and what we see in later iterations.
Yeah, my prediction is that bar results are going to be very interesting. We're going to be living in yet another, the old Chinese curse, may you live in interesting times. And I feel like we are in the midst of that, which is we don't know. And it makes it very hard to prepare your students because you can't tell them exactly what they're going to encounter.
Then I imagine there'll be a point where they take all the questions and they use these are the question sets, and they have a human being grade it, and they'll run it through AI and compare the results. They'll do that for 2 or 3 years and then finally just turn it over to AI and let the AI do it. I mean, who knows?
AI is getting better and better. I was
It
talking.
certainly is. I had to schedule an appointment for my car, and I called after hours, and this woman was ready to talk to me about anything I wanted to talk about to get my car appointment set up. It was amazing, let alone great exams.
Right. Well, for example, I was having trouble. One of my students, this frequently is a problem for law students, is they write conclusory language. So instead of explaining what they're
Right.
doing, they just conclude.
You
They
don't
say,
show the work.
this is murder. And you're like, okay, well, I agree it's murder, but why is it murder? And how do you prove that? And I threw their exam answer into ChatGPT in front of them. And I said, is this conclusory? And it said, yes. And it gave me a giant long paragraph explaining why it was conclusory. And I said, maybe, practice. It's amazing. It's getting better and better and better. And I wager it will be part of the grading process eventually.
Yeah. When I went to law school, the school had a 90% pass rate on the exam. And the way they did it was they taught us to answer with a question. Did so-and-so, murder so-and-so when they pulled a weapon and with intent da, 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 da. And then you go through it. So you tell the person doing the writing, the grading, that you know all the issues, and they'll give you 90 points and then move on, But yeah, you got to be careful about how you show your work. Now I'm teaching in the business school, and I'm just trying to get them to read and to really know what a first-class mail is. Believe it or not, they don't know what first-class mail is.
Since what I've noticed, and Dean Knight may notice this as well, since the pandemic, there's been a shift in student preparedness, and it's a different. They're lovely people, and they're
Yeah.
working hard, but it's different in a way that's interesting.
Yeah, somebody pointed out to me, if you run the numbers, 2020, this is 2025, a lot of those kids started college on Zoom,
Mhm.
never experiencing the pressure of in person, and so it kind of ripple effect. Getting us off track, I apologize.
I do think, though, that that does impact the bar exam. It does impact outcomes. Um, and Dean Knight's point of she's glad that Florida's waiting another 2 years. My suspicion is, and I hope I'm wrong, is that this is going to be a really problematic bar when they run the bar the first time with NextGen. The results are going to be very unpredictable. Let's hope they're unpredictable in a positive way, but I think they're going to be unpredictable, and that's going to result in change
Mm,
because they haven't had a chance to validate these questions. There's a lot of work they haven't done, and that's going to impact students. And I would add, I think this is especially important when we think of communities of color. We know that certain kinds of exams result in certain students underperforming. So they perform less well than they would in other situations. So timed exams, high pressure timed exams are a good example of that. And so I think that you could actually see some very marked effects on different communities. And we'll have to see, but I think that that's going to be something that we'll have to carefully watch.
All right.
Daniel, other questions?
No, that's it. All right. It was wonderful to have both of you here. It was nice reaching out to you and kind of getting familiar with this process too, of reaching out and then getting both of you to speak about these important topics and changes that are happening in our environment. So it's great to hear about those changes. As someone who's aspiring to be a lawyer, it's good to hear about what policy changes are going on there. And I guess I'll be taking that NextGen exam sometime in the future. Well, so I'm gonna have to prepare for that too. But yeah, again, it's good talking to both of you. And that will wrap up our town hall. Dennis, Sadia, do you have anything else to add?
Well, I just wanted to, on behalf of the Urban League, wanted to thank the two of you for this. This was really intriguing, and I know it's coming from people that really know what's going on in the field, and I really appreciate it. I also did want to congratulate Dean Knight on the bar results. Please send my best to the dean and the faculty there. Did a wonderful job. I knew they would. And of course, Scott was there helping. So congratulations, Scott.
Well, maybe that's why it was under 100%, right? Let's hope that that's not the case.
Anyway, congratulations on that. And thank you for being with us tonight. And hopefully we can do this again soon and see where things have progressed.
Sounds great. Well, thank you both. Thanks all of you for inviting us.
Yeah, thank you so much.
Thank you as well. Good night.
Take care.
All right, good
Bye-bye.
night, everyone.
everyone.
Bye.